Hello, this is the video on Discovery Overview, beginning with Chapter 8 in the text in Civil Procedure. Chapter 8 is basically just a quick glance at what is discovery, why is it important, what are you going to need to know, and then we'll talk about the types in subsequent videos as we cover them specifically. So first thing you have to know is what is discovery. Discovery is not a channel. In law, it's not like its normal definition. Discovery is a whole concept in law, in civil cases, and really in criminal cases also, that involves the legal process for searching for facts relevant to a case. Discovery is a whole set of circumstances and abilities to ask questions to the other side to get all of the information for your case. Because in the U.S. system, we do not have trial by surprise or trial by ambush. And so discovery is the process to kind of deal with that by having the two sides in a civil case, or two or more sides, give each other all their relevant information to bring forth their cases. So that's what discovery is. It's a formal process and all of that stuff. So what's the purpose? The purpose is to avoid trial by ambush. It's to create a process where it's fair and to expedite in the judicial process generally. Okay, so that's the one thing. What's the purpose? Is to make it judicially efficient. Okay, the resolution of cases become judicially efficient and all of those fun things to make it quicker. That way we get to the heart of the actual legal issue, and then we resolve that by the more lengthy processes of a court system, things like that. Okay, another important concept in discovery is what's known as ESI, or electronically stored information. You'll hear it read in the book about what is electronically stored information. That's a whole new area of discovery that's come up because of the information age and all the stuff that we now generate. My example is in the old days, we used to write letters of everything we were going to talk about between our coworkers, and anything that happened in a business. In a corporation or any organization, you would write a letter or internal memo or something to that effect. In today's world, we write emails to everyone all the time. That stuff becomes all kinds of discoverable information. It also turns things into mountains of paper, as opposed to in the past, we might have had a more lengthy letter or memo that went to a whole group of people, and then a more lengthy, or it didn't have to be long, but it would have been more thought out possibly. But it would have been one document that would have been longer thinking process that then was sent back. So you only have maybe 2 or 3 pieces of paper to have kind of a whole discussion. With email now, sometimes we have like 50, 60 emails to cover that, and everybody chimes in, blah, blah, blah. You know how that goes. That becomes really quite the challenge in discovery about how do we go through all of this information. And there are a bunch of new rules in the federal system, mainly the federal system. State system still doesn't really deal specifically with this, but there are federal rules specific to the ESI. Just some information to know, there's something called metadata. Metadata is all of the stuff that's behind the scenes in your documents that says when you edited things, when you updated things, when you made this change or that change. Kind of important, kind of secretive documents. Sometimes you might, not secretive, but might be information you don't really want other people to know. For instance, if I draft a document as a lawyer on behalf of you, that metadata would indicate that I was the original author, and then that you used it and things like that. So that's what metadata is. A lot of people want to try to not really have that tracking, that track changes feature that is metadata. Litigation holds, that involves like the new federal rules basically require that if you know that something may be possibly brought up as a civil case, that you have to hold on to those emails, even if your regular destruction process or destruction of documents or retention, maybe that's the better way to say it, your retention plan would ask for those documents to be destroyed. If they are possibly, or you have some reason to believe they may at some point become part of a civil case, you have to put a litigation hold so you do not destroy those documents. Good examples may be things outside the statute of limitations, particularly maybe in medical records, stuff like that. That's what litigation holds are all about. E-discovery is just that entire process that we're talking about that involves these electronically stored information. How do we go after them? What do we do? It's a whole new area. There are people that do that. Sometimes you'll see contract work in that area. You're just reviewing discovery and trying to find important things. It can be complicated. There's software involved sometimes. Computer programmers that are just designing search engines to just deal with finding information irrelevant to cases, that kind of stuff. So just be aware of those areas. The e-discovery is pretty big in all civil litigation right now because a lot of documents are just electronic. And so in some ways it's easier to search it by computer, but in other ways it's more complicated because it's more complicated because there's so much more of it. Okay, so let me tell you then the types of discovery. You have what are known as depositions, interrogatories, requests for production of documents and things, or entry upon land for inspection. That's one type of discovery, by the way. Physical or mental examinations, and requests for admission. We'll talk about those in detail. Scope of discovery. What is discovery? We already talked about that, but what is discoverable? So you must have a legal definition. You'll see this below. It's in Rule 26B. I know it's in West Virginia, 26B. I know, and the 26B is the federal rule. I believe that's true in Ohio. Probably most states follow the federal rules on what is discoverable and like which one it is, 26B. Within discovery, you have motions to compel and protective orders. Motions to compel are those kinds of motions that say that for some reason you are not answering your discovery. The court will order you to do that. So that's just a process to do that. Sometimes you're either just not answering, you haven't communicated back. Other times you've made an objection and there needs to be a court decision to say whether or not you have to do it over the objection. Sometimes if somebody makes a request for some document or something that you believe to be protected or protectable that doesn't have to be disclosed to the other side, you might initiate it through a protective order, a motion protective order. A lot of times when it comes to medical records and any kind of sensitive information, the parties will agree to a protective order. Basically, a protective order says that, we'll give you this information, and the court's going to be specifically protecting that information. So if I give it to you, you cannot give it to anybody else. And if you do, you violate a court order, and you don't want to do that. What are the basic limits on discovery? Basically, what we find, and let me scroll down here a second to see 26B, which is down here. 26B makes a very, very broad statement about what is discoverable. And I'll show you right there. Parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claim or defense. Okay? So you have two big terms there. What is relevant? Everything that is relevant is basically discoverable. And you have non-privileged. So we're going to talk about the privileges here in a minute. Some things are not subject to being disclosed because you get to keep them to yourselves. And I also want to hit the last part here. There's some other considerations in the middle, but the last part is information within the scope of discovery need not be admissible in evidence to be discoverable. So you have like really three big terms: non-privileged, relevant, and discoverable admissible. That means basically that just because I couldn't use it at trial doesn't give you a reason to keep it from me. So anything that is any non-privileged matter that is relevant is discoverable. So that's really important to understand. The only objection really is on privilege. What are the privileges? The main one, very important to lawyering in general, the practice of law, is the attorney-client privilege, which means the things that are said to an attorney as from the client are privileged. They may not be disclosed to the third party or the court or the other party or the court because that's the heart of the attorney-client relationship. If I have to disclose things to other people, then why would a client ever tell me anything? Okay, that's the attorney-client privilege. So, okay, realize then a motion discovery is provided, and it involves conversations that the lawyer and the client had about the client's case. That is privileged, and that means that even though it's possibly discoverable because it's privileged, then it's not. I don't have to hand it over. The work product privilege or the litigation privilege, that's basically where the lawyer generates information in course of creating the case, getting ready for case, formulating strategy and all those things. That is a privilege, okay? Because I get to develop my product to work, my memos, my internal memos, things like that, those are all protected from the other side. A lot of times what happens though, and I've thrown out this concept of inadvertent waiver of attorney-client privilege or the work product privilege. What happens with all that mountain of ESI, of that electronic discovery? Sometimes we accidentally send an email to the wrong person or a text message. You know, we know that in today's world too. You accidentally send it to the wrong person. In the old days, if you did that, if let's say you wrote a letter and you mailed it to the other side and you meant to write it to your client, and it told your whole strategy in the case, you just waived attorney-client privilege. You can't protect it. You were the fool, so we said you waived. The privilege is gone. You can't go and say they can't use that against me now because you gave it. You waived that privilege. In today's world, with this electronic discovery and all this stuff can go out, and you can inadvertently hit send and send it to the wrong counsel or whatever. The rules say that basically, as long as you took reasonable steps to protect the evidence and you tried to remedy the accidental release by like sending, if you ever work in a law office or you ever see what comes from insurance companies and lawyers and accountants and financial planners, at the bottom there's this thing that says there's some statement to the effect of, this is addressed to, this is only for the eyes of the recipient, the person to receive this email, and anybody else should immediately destroy it. Those are the things that are trying to remedy the accidental release of information. So we have that new piece in the e-discovery process. We have the medical privilege, so statements that you make to a doctor for the purpose of diagnosis and treatment, or that you make to your doctor in that course, those are privileged and only in minimal things. Confessor, penitent privilege, that's the old the cloak of the clergy privilege, which if you tell your priest, your pastor, or your religious head something, it's privileged. You have the privilege against self-incrimination, that's the Fifth Amendment, and some things are confidential and you can't violate protective orders. So those are the limits and all those things. Okay, under the federal rules, I also want to hit some. This is not a state rule, this is only federal rules. In the federal rules, they actually require this, what they call mutual or mandatory disclosure under Rule 26. That means at the time the case is filed, and then shortly thereafter in the time frames that are provided, you must disclose without waiting for a discovery request the following information. Basically, the name and address, the contact information, and of anybody who is likely to have discoverable information. So you have to give those that information quickly. Identify those people for the other side. The second thing is you have to release all documents that basically support your claim or defenses. So you have to do that really quickly too. A computation of the damages, so you have to set forth your damages, and you have to provide your insurance agreement discussing any possible insurance coverage. What is the point of these 4 rules, these 4 mandatory disclosures? Basically, to expedite this process. Let's go head towards discovery or towards settlement. The whole kind of gist of the federal rules of civil procedure and really the state rules of civil procedure also is to get you to resolve the case. Let's encourage resolution. Let's encourage each other to talk and try to come up with a mutually beneficial result. Okay, we call those settlements. The federal rules also have what are called the meet and confer rule. That means that 21 days before you meet with the court, you better go sit down with each other and kind of agree to as many things as you can. Obviously, you have the mandatory disclosures that happen pretty quickly. Then you have some other things, but you have this continuing duty to supplement. So if you find new people that have discoverable information, you find new documents that support your claim or defense. If your damages, you have a different basis of calculation for that. All of those things you have a duty to supplement those over time. So then with all that said, I go to the bottom and I say, why do parties cooperate in discovery? That's a question. That's an interesting question that I think you have to think about, and I can't really just give you an answer. Why do parties cooperate? Isn't it easier for me just to hold that information back from the other side? Wouldn't I be more likely to win? Okay, so why do they cooperate? Why do they do it quick and easy? All those things. Why are they trying to do it as simply as possible? Why do they cooperate? Okay,